Eminent. So, I am here to discuss some cases in constitutional law too. And I just a disclaimer that I do not own the materials that I'm going to use. These are materials used by my classmates in our constitutional law 2 classes. Okay, the first case is Philippine Association of Service Exporters versus Franklin Grillon. The facts of the case, DO number 1 was issued, which temporarily suspends the deployment of Filipino domestic and household workers. PASE challenges its validity on the following grounds: that it is discriminatory as it only applies to female workers, and that it is an invalid exercise of the lawmaking power. The Solicitor General argued that the respondent have lifted the ban in states where there exists bilateral agreement with the Philippines and existing mechanism providing for sufficient safeguards to ensure the welfare of Filipino workers. In submitting the validity of the challenge guidelines, the Solicitor General invokes police power. The issue is whether or not DO1 is a valid exercise of police power under the Constitution. And the ruling is that, yes, the petitioner has no reason why the contested measure should be nullified. The state exercises police power, which is a power to coextensive with self-protection and is not inaptly termed by law of overwhelming necessity. There is no question that the assailed law applies only to female contract workers, but it does not make an undue discrimination between the sexes. In fact, equality under the Constitution does not import a perfect identity of rights among all women and men. The next case is Ichong versus Hernandez. The facts of the case are: RA 1180, otherwise known as Retail Trade Nationalization Law of 1954, it proposes to regulate the retail business by disallowing aliens from disengaging in the retail trade. Aliens actually engage in retail before approval of the act are allowed to continue subject to conditions of the said act. Petitioner assails the constitutionality of RA 1180. Petitioner said that retail is a common and honest occupation and therefore beyond the power of the legislature to prohibit and penalize. SG answered that it was passed as a valid exercise of the police power of the state. The issue is whether or not retail falls within the power of the state to prohibit and penalize. The ruling is that RA 1180 is constitutional. Police power is the power of promoting public welfare by restraining and regulating the use of liberty and property. It is the most pervasive and least limitable and the most demanding of the three powers. Salus populi es supreme lex, sic utere tuut alienum non legas. Evidence shows that there is alien predominance and control of the retail trade, which exposed the country to manipulation of goods and commodities by the aliens. By enacting the law, the state prevented an actual danger to the economy. Clearly, the legislature was within the bounds in enacting the law. The next case is Lutz versus Araneta. Facts. Here, appellant Walter Lutz is in his capacity as the judicial administrator of the intestate of the deceased, Antonio Jaime Ledesma, seeks to recover from the collector of the Internal Revenue the total sum of 14,666.40 paid by the estate as taxes under Section 3 of Commonwealth Act No. 567, aka the sugar adjustment for the crop years of the said years. Commonwealth Act No. 567, Section 2 provides for an increase of the existing tax on the manufacturing of sugar on a graduated basis on each pickle of sugar manufacturer, while Section 3 levies on the owners or persons in control of the land devoted to the cultivation of sugarcane and ceded to other for consideration on lease or otherwise a tax equivalent to the different money the money value of the rental or consideration collected, and the amount representing 12% of the assessed value of such land, it was alleged that such tax is unconstitutional and void, being levied for the aid and support of the sugar industry exclusively, which, in plaintiff's opinion, is not a public purpose for which a tax may be constitutionally levied. The action was dismissed by the CFI, thus the plaintiff appealed directly to the Supreme Court. The issue is whether or not the tax imposition in the Commonwealth Act number 567 is unconstitutional. The ruling of the Supreme Court held that the fact that the sugar production is one of the greatest industry of our nation, sugar occupying a leading position among its export products, that it gives employment to thousands of laborers in the fields and factories, that is a great source of the state's wealth, is one of the most important source of foreign exchange needed by our government, and thus pivotal in the plans of a regime committed to a policy of currency stability. Its promotion, protection, and advancement therefore redounds greatly to the general welfare. The ruling is hence it was competent for the legislature to find that the general welfare demanded that the sugar industry be stabilized in turn and in wide field of its police power. The lawmaking body could provide that the distribution of benefits therefrom be readjusted among its components to enable it to resist the added strain of the increase in taxes that it had to sustain. The subject tax is levied with a regulatory purpose to provide means for the rehabilitation and stabilization of the threatened sugar industry. In other words, the act is primarily a valid exercise of police power. In the case of Florentina A. Lozano versus Honorable Antonio M. Martinez, the facts here is that BP 22 punishes a person who makes, draws, and issues a check without knowing at the time of issue that he does not have sufficient funds in credit with the drawee bank for the payment, which check is subsequently dishonored by the drawee bank for insufficiency of funds or credit, or would have been dishonored for the same reason had not the drawer without any valid reason ordered the bank to stop payment. Those who question the constitutionality of the sailed law insist that it is constitutionally impermissible for the legislature to penalize a person for non-payment of debt ex contractu. The issue is whether or not the enactment of BP 22 is a valid exercise of police power. Ruling: yes, the enactment of BP 22 is a declaration by the legislative that as a matter of public policy, the making and issuance of a worthless check is deemed a public nuisance to be abated by the imposition of penal sanction. An act may not be considered by society as inherently wrong, hence not malum inse, but because of the harm that it inflicts on the community, it can be outlawed and criminally punished as malum prohibitum. The state can do this in the exercise of police power. The Department of Education, in the case of the Department of Education, Culture, and Sports versus San Diego, the facts: private respondent is a graduate of the UE with a degree of Bachelor of Science in Zoology. He failed the NMAT 3 times. When he applied to take it again, DEX rejected his application. He then filed his case to compel his admission to the test. Constitutional rights to academic freedom and quality education, and challenged the constitutionality of MECS Order Number 12, which states that a student shall not be allowed to take NMAT exam after 3 successive failures. The issue is whether a person who has twice failed the NMAT is entitled to take it again. Held no, because MEX Order Number 12 is constitutional. Police power is validly exercised if the interest of the public is generally requiring the interference of the state, and the means employed are reasonably necessary to the attainment of the object sought to be accomplished and not unduly oppressive upon individuals. The said order is within the ambit of police power. Lawful subject: responsibility of the state to ensure medical profession is not infiltrated by incompetence. That the lawful method is not arbitrary or oppressive, and the right to quality education not absolute. In the case of Enot versus Intermediate Appellate Court, petitioner in this case transported 6 carabaos in a pump boat from Masbate to Iloilo on January 13, 1984. When they were confiscated by the police station commander of Barotac Nuevo, Iloilo for the violation of EO 626A, which prohibits the slaughter of carabaos except under certain conditions. Petitioner sued for recovery, and the trial court of Iloilo issued a writ of replevin upon this filing of a supersedeas bond of 12,000 pesos. After considering the merits of the case, the court sustained the confiscation of the said carabaos, and since they could no longer be produced, ordered the confiscation of the bond. The court also declined to rule on the constitutionality of the EO as raised by the petitioner for lack of authority and also its presumed validity. The issue is whether or not the said executive order is unconstitutional. And the ruling is yes, though police power was invoked by the government in this case, for the reason that the present condition demand that the carabaos and the buffaloes be conserved for the benefit of small farmers who rely on them for energy needs. It does not, however, comply with the second requisite for a valid exercise of the said power, which is that there be a lawful method. The reasonable connection between the means employed and the purpose sought to be achieved by the questioned measure is missing. The challenged measure is an invalid exercise of police power because the method to conserve the carabao is not really necessary for the purpose of the law, and worse, is unduly oppressive. To justify the state in the imposition of its authority in behalf of the public, it must be, number one, that the interests of the public generally, as distinguished from those of a particular class, require such interference, and number two, that the means employed are reasonably necessary for the accomplishment of the purpose and not unduly impressive upon individuals. In the case of City Government of Quezon City and City Council of Quezon City versus Honorable Judge Vicente Ericta, the respondent Himlayang Pilipino filed a petition seeking to annul Section 9 of Ordinance 6118S-64, requiring private cemeteries to reserve 6% of its total area for the burial of paupers. On the ground, it is contrary to the Constitution. The petitioner contends that the said order was a valid exercise of police power under the General Welfare Clause, that the respondent court declared the said order null and void. And the issue is whether or not Section 9 of the ordinance in question is a valid exercise of the police power. And the Supreme Court ruled no, that the ordinance not only confiscates but prohibits the operation of a memorial park cemetery. There is no reasonable relation in setting aside of at least 6% of the total area of private cemeteries for charity and the promotion of health, morals, good order, safety, or the general welfare of the people. The ordinance in question not only confiscates but also prohibits the operation of a memorial park cemetery. It deprives a person of his private property without due process of law, nay, even without compensation. In the case of Association of Small Landowners versus Secretary of Agrarian Reform, the facts of the case are, petitioners are questioning the constitutionality of PD number 27 and EO numbers 228 and 229, averring that the just compensation contemplated by the Bill of Rights is payable in money or in cash and not in the form of bonds or other things of value. However, in an amended petition, petitioners contended that such law have been impliedly repealed by RA number 6657, where compensation shall be paid partly in cash and in government financial instruments negotiable at any time. The issue is whether or not Section 18 of RA 6657 is unconstitutional, insofar as it requires the owners of the expropriated properties to accept just compensation, therefore in less than money, which is the only medium of payment allowed. Ruling: money as sole payment for just compensation is merely a concept in traditional exercise of eminent domain. The Agrarian Reform Program is a revolutionary exercise of eminent domain. The expropriation before us affects all private agricultural lands whenever found and of whatever kind, as long as they are in excess of the maximum retention limits allowed their owners. The proportion of cash payment as determined on the basis of the areas of the lands expropriated is not unduly oppressive upon the landowner. In Manila Memorial versus Secretary of DSWD, The facts is RA 7432 was passed into law, granting senior citizen 20% discount on certain establishments. To implement the tax provisions of RA 9257, the Secretary of Finance and DSWD issued its own rules and regulations, hence this petition. Petitioners are not questioning the 20% discount granted to the senior citizens but are only assailing the constitutionality of the tax deduction scheme prescribed under RA 9257 and the implementing rules and regulations issued by the DSWD and the DOF. Petitioners posit that the tax deduction scheme contravenes Article 3, Section 9 of the Constitution, which provides that private property shall not be taken for public use without just compensation. Respondents maintain that the tax deduction scheme is a legitimate exercise of the state's police power. The issue, whether the legally mandated 20% senior citizen discount is an exercise of police power or eminent domain. The ruling, yes, the 20% senior citizen discount is an exercise of police power. It may not always be easy to determine whether a challenged governmental act is an exercise of police power or eminent domain. The judicious approach, therefore, is to look at the nature and effects of the challenged governmental act and decide on the basis thereof. The 20% discount is intended to improve the welfare of senior citizens at their age, are less likely to be gainfully employed, more prone to illnesses and other disabilities, and thus in need of subsidy in purchasing basic commodities. It serves to honor senior citizens who presumably spent their lives on contributing to the development and progress of the nation. In turn, the subject regulation, the pricing, and hence the profitability of a private establishment. The subject regulation may be said to be similar to, but not be substantial distinctions from price control, or rate of return on investment control laws, which are traditionally regarded as police power measures. The subject regulation differs there from that. Discount does not prevent the establishments from adjusting the level of prices of their goods and services, and the discount does not apply to all customers of a given establishment but only to the class of senior citizens. Nonetheless, to the degree material to the resolution of this case, the 20% discount may be properly viewed as belonging to the category of price regulatory measures which affect the profitability of establishments subjected thereto. On its face, therefore, the subject regulation is a police power measure. The City of Manila versus Chinese Community of Manila. Facts. The plaintiff prayed that certain lands be expropriated for the purpose of constructing a public improvement into an extension of Rizal Avenue, which is necessary for the plaintiff to exercise in fee simple of certain parcels of land. Defendant contends that the expropriation was not necessary as a public improvement and that plaintiff has no right to expropriate the said cemetery for street purposes. The lower court declared that there was no necessity for the said expropriation. The issue is whether or not the right exists for the exercise of eminent domain. The ruling is that the right to take private property for public purposes necessarily originates from the necessity, and the taking must be limited to such necessity. The court, with very clear and explicit reasons supported by ambulance of authorities, decided that there was no necessity for the expropriation of the particular strip of land in question, and absolved each and all of the defendants from all liability under complaint without any finding as to cost. In the case of Republic versus Philippine Long Distance Telephone Corporation, or PLDT, in 1947, the Bureau of Telecommunications set up its government telephone system by renting trunk lines of the PLDT. The Bureau agreed that the use of the trunk lines rented would be limited only to government offices and they would not use the same or for public use. PLDT disconnected the trunk lines being rented because the Bureau extended its services to the public. The Bureau proposed that they enter into an agreement to meet the demand for the telephone service. PLDT refused, hence the case. The issue is whether or not the defendant PLDT can be compelled to enter into a contract with the plaintiff. And the Supreme Court held that the parties cannot be coerced to enter into a contract where no agreement had been between them as to the principal terms and conditions of the contract. However, it was noted that PLDT was failing to meet the rising demand of telecommunication services. Thus, through eminent domain, the Bureau may require PLDT to permit interconnection of its trunk lines. It has been held that acquisition of an easement of right of way falls within the purview of eminent domain. No reasons why eminent domain may not be availed of this case. In the case of People versus Fajardo, the facts: during Fajardo's term as mayor of Baao, the municipal council passed an ordinance requiring any person or persons planning to construct or repair a building to obtain a written permit from the mayor. His son-in-law requested a permit but was denied. They now question its constitutionality, that it gives the mayor unrestricted power to grant or deny permits and that it oversteps the bounds of police power. The amounts to a taking of appellant's property without just compensation. The issue is whether or not the assailed ordinance is unconstitutional. The ruling, the court ruled that the ordinance is unreasonable and oppressive. It deprives Fajardo the right to use his own property. By taking the property, there must be just compensation and opportunity to be heard, and there was none in this case. No purpose was stated for the requiring of such permits, and no condition for its grant or refusal was given to guide the mayor, which makes it prone to abuse and discrimination. In the Republic of the Philippines versus Viuda de Castelvi, the government occupied the land of Carmen M. Viuda de Castelvi by virtue of a contract of lease on a year-to-year basis. The Republic sought to renew the same, but Castelvi refused. The AFP refused to vacate the lease premises after the termination of the contract because it would be difficult for the army to vacate the premises in view of the permanent installations and other facilities that were erected and already established on the property. Castelvi then brought suit to eject the Philippine Air Force from the land. While this ejectment case was pending, the Republic filed complaints for eminent domain against the respondents over the 3 parcels of land, but the court authorized the Republic to take immediate possession of the lands upon payment of just compensation with the provincial treasurer of Pampanga. The issue is whether or not the taking of the property commenced with the filing of the action or upon the occupation. The ruling is taking under the power of eminent domain may be defined generally as entering upon private property for more than a momentary period and under the warrant or color of legal authority, devoting it to a public use or otherwise informally appropriating or injuriously affecting it in such a way as substantially to oust the owner and deprive him of all beneficial enjoyment thereof. Thus, the taking of the property should not be reckoned as of the year 1947, when the Republic first occupied the same pursuant to the contract of lease, and that the just compensation should not be determined on the basis of the value of the property as of that year. Therefore, the taking under expropriation commenced with the filing of the complaint. In Amigable versus Cuenca, Amigable is the owner of lot number 639 as shown by transfer certificate. No annotation in favor of the government appears at the back of the certificate. Without prior expropriation, the government used a portion of the said lot for the construction of Mingo and Gorordo Avenues. Amigable requested payment to the office of the president but to no avail. Thus, she went to the court with a complaint against the Republic of the Philippines. The issue is whether or not the appellant may properly sue the government without violating the doctrine of governmental immunity from suit without its consent. Held Ministerio versus Court of First Instance of Cebu, where the government takes away private property for public use without expropriation of negotiated sale, the aggrieved party may properly maintain a suit against the government without violating the doctrine of government immunity from suit. No annotation in favor of the government appears in the certificate. Appellant remains the owner of the said lot, that she can bring an action to recover possession of the said lot. However, the relief would only be due compensation, which is the value at the time of the taking with legal interest. In Philippine Press Institute versus Comelec, the Philippine Press Institute Incorporated is before the court assailing the constitutional validity of Resolution number 2772 issued by Respondent Commission on Elections and its responding COMELEC directive dated March 22, 1995 through a petition for the certiorari and prohibition. Petitioner PPI is a non-stock, non-profit organization of newspaper and magazine publishers. Section 2, COMELEC Space, states that the Commission shall procure free print space of not less than 1/2 page in at least one newspaper of general circulation in every province or city for use as COMELEC space from March 6, 1995. In the case of candidates for senator and from March 21, 1995 until May 12, 1995, in the absence of said newspaper. COMELEC space shall be obtained from any magazine or periodical of said province or city. Section 3, Uses of COMELEC space. COMELEC space shall be allocated by the Commission free of charge among all candidates within the area in which the newspaper, magazine, or periodical is circulated to enable the candidates to make known their qualifications, their stand on public issues, and their platforms and programs of government. COMELEC space shall also be used by Commission for dissemination of vital election. PPI asked us to declare COMELEC Resolution 2772 unconstitutional and void on the ground that it violates the prohibition imposed by the Constitution upon the government and any of its agencies against the taking of private property for public use without just compensation. On April 20, 1995, this court issued a temporary restraining order enjoining COMELEC from enforcing and implementing Section 2 of Resolution number 2772 as well as the COMELEC directives addressed to various print media enterprises, all dated 22 March 1995. The court also required the respondent to file a comment on the petition. The Office of the Solicitor General filed its comment on behalf of Respondent COMELEC, alleging that COMELEC Resolution number 2772 does not impose upon the publishers any obligation to provide free print space in the newspapers as it does not provide any criminal or administrative sanction for non-compliance with that resolution. The Solicitor General argues that even if the questioned resolution and its implementing letter directives are viewed as mandatory, the same would nevertheless be valid as an exercise of the police power of the state. The issue is whether or not Resolution 2772 is void on the ground of deprivation of use without compensation of newspaper. And the ruling of the Supreme Court is yes. To compel print media companies to donate COMELEC space amounts to taking of private personal property for public use. The extent of the taking of deprivation is not insubstantial, measured by the advertising rates ordinarily charged by newspaper publishers, whether in cities or in non-urban areas. The taking of print space here sought to be effected may first be appraised under the rubric of expropriation of private personal property for public use. The threshold requisites for a lawful taking of private property for public use need to be examined here. One is the necessity for the taking, another is the legal authority to effect the taking. The element of necessity for the taking has not been shown by the respondent COMELEC. It has not been suggested that the members of PPI are unwilling to sell print space at their normal rates to COMELEC for election purposes. It has not been suggested that the COMELEC has been granted the power of eminent domain either by constitution or by the legislative authority. A reasonable relationship between the power and the enforcement and administration of election laws by COMELEC must be shown. The taking of private property for public use is, of course, authorized by the Constitution but not without payment of just compensation. In the case of Sumulong versus Guerrero, NHA filed a complaint of expropriation of parcels of land including the lots of Sumulong and Bidanes Balawing. NHA deposited the total market value with PNB pursuant to the policy on the expropriation of private property for socialized housing upon payment of just compensation. Judge Guerrero decided in favor of NHA. Sumulong then filed a motion for reconsideration on the ground that they had been deprived of their property without due process of law and that socialized housing was not public use. The issues, thus the taking of private property for socialized housing which would benefit a few and not all citizens constitute taking for public use? Yes. The ruling of the Supreme Court is that the expropriation valid and in the accordance with the law? No. The socialized housing project of the NHA is aimed to provide low-cost housing for low-salaried government employees. Housing is a basic human need. The property rights of the people should yield for the common good. After which, there must be just compensation before the actual taking. However, in this case, there was a violation of procedural due process because the property was immediately stripped from them without being given the chance to be heard. In Manosca versus Court of Appeals, petitioner Manosca inherited a land located at P. Burgos Street at Taguig City. It turned out that the land was the birth site of Felix Manalo, as ascertained by the National Historical Institute. Accordingly, the Republic instituted a complaint for expropriation. Petitioners opposed the complaint on the ground that the intended expropriation was not for public use. And the issue is whether or not the public use required of eminent domain is extant in the attempted expropriation by the Republic of a land so declared by the National Historical Institute as a national historical landmark. It was held that public use is the general concept of meeting public need or public exigence. The idea that public use is limited to clear case of use by the public has been abandoned. Synonymous with public interest, public benefit, and public welfare in this case, the purpose of the law is to recognize the contributions of Felix Manalo. Clearly, there is public benefit involved when the government sought to expropriate the birthplace of Felix Manalo to be able to preserve it for future generations of Filipino who deserve to know their history not only through books but by actual pieces of history. The next case is EPZA versus Dulay. PD 1811 reserved a certain parcel of land for the public domain for the establishment of an export processing zone by EPSA. However, not all the reserved areas was public land. A portion was owned by San Antonio Development Corporation. EPSA then filed a complaint for expropriation. Dulay issued a writ of possession in favor of EPSA. Assigned commissioners valued the land, but EPSA filed an MR because under PD 1533, it is the owners of the assessors which dictate the fair and current market value. Whether or not the issue is the exclusive and mandatory mode of determining just compensation in PD 1533 was valid and constitutional, and the ruling of the Supreme Court is that no, PD 1533 is unconstitutional for encroaching judicial prerogatives. The determination of just compensation in eminent domain cases is a judicial function. The executive or legislature may make the initial determinations, but when a party claims of a violation of the guarantee in the Bill of Rights, that private property may not be taken for public use without just compensation. No statute, decree, or order can mandate that its own determination shall prevail over the court findings. In the Municipality of Parañaque versus VM Realty Corporation, the Municipality of the Parañaque issued Resolution number 9395, which caused the institution of complaint for expropriation over the lands of respondent for the purpose of providing socialized housing projects. The trial court issued an order authorizing petitioner to take possession of the property upon deposit of an amount equivalent to 15% of the MFB based on the tax declaration. Thereafter, respondent alleged that the complaint failed to state a cause of action because it was filed pursuant to a resolution and not to an ordinance as required by RA 7160. And the cause of action, if any, was barred by a prior judgment or res judicata. Then the trial court nullified its first order and dismissed the case. The trial court decision was affirmed by the Court of Appeals, hence this petition. Petitioner contends that the resolution approved by the Municipal Council for the purpose of initiating an expropriation case substantially complies with the requirements of the law because the terms ordinance and resolution are synonymous for the purpose of bestowing authority and the local government unit through its chief executive to initiate the expropriation proceedings in court in the exercise of the power of eminent domain. The issues is whether or not a resolution duly approved by the municipal council has the same force and effect of an ordinance and will not deprive an expropriation case of a valid cause of action, and whether or not the principle of res judicata will bar the exercise of the state of the power of eminent domain. The first issue is no, the power of eminent domain is lodged in the legislative branch of government, which may delegate the exercise thereof to LGUs. Other public entities and public utilities. Section 19 of RA 7160 lays down the following essential requisites before an LGU can exercise the power of eminent domain. An ordinance is enacted by the local legislature council authorizing the local chief executive in behalf of the LGU to exercise the power of eminent domain or pursue expropriation proceedings over a particular private property. The power of eminent domain is exercised for public use, purpose, or welfare, or for the benefit of the poor and the landless. There is payment of just compensation as required under Section 9, Article 3 of the Constitution and other pertinent laws. A valid and definite offer has been previously made to the owner of the property sought to be expropriated, but said offer was not accepted. In the case at bar, the local chief executive sought to exercise the power of eminent domain pursuant to a resolution of the municipal council. Thus, there was no compliance with the first requisite that the mayor exercising the right to eminent domain be authorized through an ordinance. A municipal ordinance is different from a resolution. An ordinance is a law, but a resolution is merely a declaration of the sentiment or opinion of a lawmaking body on a specific matter. An ordinance possesses a general and permanent character, but a resolution is temporary in nature. Additionally, the two are enacted differently. A third reading is necessary for an ordinance, but not for a resolution, unless decided otherwise by a majority of all the Sangguniang members. In the second issue, the Supreme Court held no, the principle of res judicata cannot bar the absolute right of the state of its agent to expropriate private property or exercise the power of eminent domain. The scope of eminent domain is plenary and, like police power, can reach every form of property which the state might need for public use. Thus, the state or its authorized agent cannot be forever barred from exercising right reason alone of previous non-compliance with any legal requirement. In this case, our ruling that petitioner cannot exercise his delegated power of eminent domain through a mere resolution will not bar it from reinstituting similar proceedings once the said legal requirement, and for that matter all others, are properly complied with. Decision, therefore, petition is denied. In the case of NPC versus Gutierrez, NPC initiated negotiation for the right of way in easement over the lot of spouses Gutierrez and Malit for the construction of its transmission lines. NPC filed eminent domain proceedings contending that the payment of the full market value of the land was erroneous, inasmuch as it was only a simple right of easement. Full ownership was retained by the respondents who were not deprived of the use of the land. As such, NPC claimed that if full market value was required, then full transfer of the ownership should be done. The issue is whether or not NPC should be made to pay a simple easement fee or the full compensation for the land traversed by its transmission lines. The ruling is that the court held that although NPC was only after the right of way easement, it perpetually deprives the respondents of their propriety rights and its ordinary use, as manifested by the limitation imposed that no plant higher than 3 m were allowed. The power of eminent domain may be exercised although full ownership was not transferred to the expropriator. Moreover, because of the high tension current conveyed by the transmission lines, danger to life and limbs cannot be discounted. So that's it for today. So again, just disclaimer, I am doing this video for my own review purposes.